Okay, everyone, we are moving on to our next presentation, and I'm thrilled to have our two speakers who are going to be presenting this today. So the title of the topic is Birth Trauma Litigation, A Mother's Perspective. And joining Richard Halpern today is going to be Dr. Laura MacGregor. And Dr. MacGregor is a writer and researcher focusing on disability, caregiving, and medical error. The author of The Invisible Woman, winner of the 2025 CBC Nonfiction Prize that just happened not too long ago. And she shares her lived experience navigating the healthcare and legal systems after her son's birth injury. I'm thrilled that she could join us today. Please welcome Dr. MacGregor and Richard.
So I'm going to start before I invite Laura up to talk about her case and give you a little background. When a number of months ago, one of my favorite experts in neonatology sent me an article written by Laura and published in the Canadian Medical Association Journal about her experience having gone through a case through trial and through appeal, and CMP sought leave to appeal to the Supreme Court of Canada. And when I read the article, I was really quite moved by it. I thought it would be great for our audience to hear her perspective on the nightmarish journey that she had through the litigation process. I think it's always important to hear these perspectives. In years past, Brenda has shared her experience with us, and I think it's very insightful to have people who actually go through it for us to better understand it. But let me give you some background on Matthew, who was born on January 27th, Laura's second child. He was asphyxiated at birth, and he passed away in March of 2020. The trial went 3 months, involved 7 fact witnesses, 11 liability experts, 9 damages experts, and the decision was not released until Matthew was 10 years old. So already a long time, right? A long time to get to trial. Then it was appealed. The appeal was appealed by Dr. Potts, who had lost at trial, and the Court of Appeal decision was released in 2012 when Matthew was 13. So again, that's an awful long time. And even then, it wasn't over because the CMP was going to seek leave, but did not get leave to appeal to the Supreme Court of Canada. I remember reading the Court of Appeal decision probably about 10 or 12 years ago. I've reread it in anticipation of today. I'm far less impressed by it today than I was when I read it the first time. But at least the right party won. Sorry, Risa. I know. Risa, who says CMP lawyer, did not try this case. She's at a different firm. And she's a completely different personality from the lawyers who did try the case. So just a bit of the history. Laura attends at 1:35. At 7:30 in the morning, her cervix is 9 centimeters. So her cervix had dilated. Remember, this is her second child. Cervix had dilated 2 centimeters in 2.5 hours, which is slow. Second time mom is expected to dilate 1.5 centimeters an hour. She starts pushing at full cervical dilatation, which is another 2.5 hours later. The baby develops a high heart rate tachycardia, which is not normal. And then there's an hour and 45 minutes of pushing. That is a long time to be pushing in a second time mom. You expect second stage, so from the time of full cervical dilatation to delivery to be less than an hour. The doctor who was managing the care did a vaginal examination, did not note the station, so that is how far the baby was descended in the maternal pelvis. There was molding, which means that there's a change in shape of the baby's head, and the baby was asynclitic, so the baby's head was tilted to the side, and the doctor recommended forceps and did not do a double setup. A double setup is when you use forceps, which is called an assisted vaginal delivery, you don't always have to do it as a double setup, but double setup means if you attempt forceps and it fails, you're ready to convert to a C-section, which would be the only way to get the baby out. The baby, doctor used Keelan forceps, but did not apply traction because the baby was left occiput posterior, turned, okay? Ideally, for baby to deliver, you want baby to be occiput anterior, baby looking at the floor when mom is lying on her back. And then different forceps were applied, and there was the baby was rotated to OA, or occiput anterior, and there were 4 variable decelerations. Variable decelerations are an indication of compression of the umbilical cord. There was a second application of forceps, and the cord prolapsed. Right, so cord prolapse, the cord drops out of the vagina before the baby, it gets squeezed, and a cord prolapse is what's called a sentinel event. It's an obstetrical emergency. And then following that, there was a bradycardia, so that's a pathologically low heart rate. Dr. Potts tries traction with no success, and then calls a cesarean section. And the baby is born by cesarean section, weighing 4,940 grams. So that's something that we call macrosomia. That's very, very big, right? Anything over 4,000 grams is considered a baby too large, and a baby. So there's a lot of reasons why this baby wouldn't deliver: malposition, asynclitic, so turned, and huge baby. Huge baby. Baby was born very depressed, and so when a labor like this is so protracted or takes so long, physicians are required to think about 3 things: power, passenger, and passage. Power are the contractions not sufficient. Passage is the pelvis too small, or passenger is the baby too big. And I always say in all of these cases, what's the question that the doctor has to ask himself every single time? In these circumstances, what are the prospects of a safe vaginal delivery? So there are a lot of adverse findings, including credibility by Dr. Potts, but what essentially happened was that when Dr. Potts applied the second forceps, before applying those forceps, the baby was the head was disengaged from the pelvis, so he didn't keep traction. The baby didn't remain engaged in the pelvis. Dr. Potts negligently disengaged the baby from the pelvis. The cord would have dropped down below the baby's head, and that's how the prolapse occurred. And one of the defenses, or some of the defenses here, was chorioamnionitis, prolonged. So chorioamnionitis is infection, and from a prolonged labor. And I write here, no defense is too ridiculous to advance. Sorry. But it's true. It's like the amniotic fluid embolism defense, right? It's a fiction. It doesn't really exist, but no defense is too stupid to advance. So Reese is going to be shit for this later, I know. Okay. That's right. So anyway, the Court of Appeal found that it was open to the trial judge to conclude that that Dr. Potts disengaged the head between the 2 applications of forceps, caused the cord prolapse, and caused the injury. I wanted to just talk about damages in this case for a second, just in relation to the talk that Pinta gave us first thing this morning. Pinta talked about the trilogy out of the Supreme Court of Canada, and one of the issues in the trilogy was whether or not, and they refer to this as mothers and sisters, right? Not husbands and fathers. Whether mothers and sisters should have to assume the burden of looking after disabled children for their lifetime. And the Supreme Court of Canada said in the trilogy, this burden does not rest on mothers and sisters. It is a compensable area of damages. Plaintiffs are entitled to acquire care services that are extraordinary at market rates from people outside the family. In in the Court of Appeal decision, in Laura's case, on behalf of Laura, her lawyers appealed the trial judge's decision, which essentially imposed on Laura, based on the fact that she had already assumed the burden for 13 years of looking after her son. The trial said, well, she's already done it, she should continue to do it, essentially. I mean, ridiculous, right? Completely ridiculous. And the Court of Appeal, instead of stepping in as they should have, said, oh, well, it's just one component of a global damages award, and it's not up to the Court of Appeal to step in to adjust one component of a damages award. Well, in these cases, it's the whole case. That's what the case is about. The case is about attendant care. Everything else is of no consequence. If you don't fully compensate and recognize the principles of the trilogy that Pinta talked about this morning, then what are you doing? So that's my criticism of the damages. I think that Laura didn't think this, but I thought she was grossly undercompensated, but there you go. So with that said, I'm going to invite Laura up and introduce you to Laura MacGregor, very brave.
We want to do this.
So why don't you stand there and I'll use this.
Okay.
Okay?
Sure.
So, okay. Is it working? Okay. Yeah. So, Laura, I think where I'd like to start is how did you get an article published in a medical journal about your journey? Tell us a little bit about how that came about.
This is actually not the first article I've published in a medical journal, but it emerged from a conversation I had with a family member who had recently experienced what was likely an adverse event or a medical error. And she was contemplating her next steps, and she approached me, because we, of course, had lived through this quite publicly, and asked about what I thought about her pursuing any kind of legal conversation. And I asked her why she would do that. And she admitted that the money was less important to her, though the error affected her fertility, and she would benefit from costs to support fertility care. But really, she wanted accountability, she wanted a conversation, she wanted an apology, and I told her that none of those things would happen, and that she should basically walk away. And I think she was disappointed, but I also think she understood why. And so that led to a reflection about my experience with medical malpractice. I hadn't talked about it a whole lot. There's a lot of shame around medical malpractice, about living through it, about being someone who files a lawsuit. The CMPA painted me as a gold-digging mother on the stand. And it's hard to live with that. It's hard to live with some of the ways I felt portrayed. And so I wanted an opportunity to write about my experience. I wanted an opportunity to speak to medicine. You'll notice I published it in a medical journal. I wanted to speak to medicine about my concerns about their relationship with the CMPA. That this is an honorable profession, and at times I think the CMPA engages in some dishonorable practices, with apologies to anybody who belongs to the CMPA in the room. So that's sort of what led me to submit the article.
So just tracing it back a little bit, what was it that prompted your first decision to reach out to a lawyer to seek compensation?
So Matthew was born and was immediately ambulanced to the McMaster Children's Hospital, and at the time I'm an occupational therapist with a master's degree who is contemplating doctoral work in the health sciences. I'm an informed mother. And MAC was great. They made sure I had access to Matthew's medical file. They understood that that helped me understand what we were living through, that helped me understand the decisions we were being asked to make about life support and about continuing with interventions. And that means I had access to the obstetrical report. And so I could see pretty quickly that the last noted station of descent was -2 spines. I'm not an obstetrician. I don't know about the appropriate use of forceps, but I do know that -2 spines is too high to use forceps. I hang out with nurses, and so I had, I was a sophisticated consumer of the medical file. In the first year, my husband and I did seek an opinion, a medical opinion. We also spoke to a couple of lawyers. My husband is a lawyer, so that helps too. We had a medical health professional and a lawyer set of parents. So we were informed, I guess, and we did seek some opinions from both medicine and from law. We ultimately chose to work with a law firm outside of our city very intentionally. What finally put me over the edge, and I don't know if you know this, Richard, I don't think I shared it with you, is I was out for a walk with a friend of mine who was a doctor, and I was struggling with what to do. I didn't want to file suit for many, many reasons. And she turned to me and she said, "They're waiting for the paperwork, Laura. They've already lawyered up." And so that to me indicated that they knew something had happened and maybe I needed to find out what happened.
That relates often to the issue of disclosure. Was there ever, there's an obligation obviously on physicians to disclose what happens during healthcare, including adverse outcomes. Was there ever any feedback from Dr. Potts about what went wrong or why?
The next time I saw Dr. Potts was in a courtroom.
And you mentioned now, and you talk about in your article a lot about apology. So tell me, as we know, we've already heard a little bit about apology. So if a doctor apologizes, there's something in Ontario called the Apology Act where the apology isn't admissible. You and I have had a long conversation about how I think it's meaningless, but you think it's very important. So talk to us about that.
Yeah, that's a hard conversation. Ultimately, how do I even begin this? I worry that the legal community conflates money with justice. And you need to remember that we did receive a large award, but we received it after 2/3 of my son's life had passed. And so we didn't have the benefit of that money for most of my son's life. I am interested, the bulk of my doctoral work looks at ethics. So I come at this conversation maybe from a slightly different angle. But I'm interested in justice. And to me, justice isn't money. Money isn't a proxy for justice. Justice includes things like a conversation about what happened, clarity and transparency, timely resolution, which we did not have, a process that places victims and their experiences in the center of concern and does what it can to protect them. I don't feel that ever happened with us. And I do feel an apology needs to be part of that. You need to remember that I continued to engage with the medical community all the time for the next 21 years of my son's life, all the time. A day didn't pass that I probably didn't have some kind of engagement with some member of the medical community. Now I'm speaking of the medical community broadly here, but I worked with doctors all the time. I continue to see doctors as a human being who needs care at times. And my trust in medicine has been fractured, has been badly damaged. An apology and some form of accountability, which I know you're interested in, would have potentially gone a long way to allowing me to continue to work with medicine in a meaningful way, in a trusting way. That is something I struggle with to this day. My trust in medicine was badly damaged.
Well, if your expectation was justice, and you went to court to achieve something, what was it? At least early on, your expectation that you might achieve justice, or what were you trying to achieve?
I was naive and stupid. Let's be clear. Yes, I naively thought that somehow some meaningful learning would emerge from the legal process. My husband, who is a lawyer, knew otherwise. and perhaps allowed me to continue to live in blissful ignorance for a while. But I don't know why I thought that, but I did. I really hoped that maybe something very meaningful would come out of this absolutely awful experience. It didn't. Nothing did, in my opinion. But my husband felt very strongly that we owed this to our son, and ultimately that was what convinced me to go along with a lawsuit.
What did you expect justice to look like going in?
I think I wanted transparency. Like many parents, I wanted to understand what happened. And I wanted to know that medicine was paying attention to what happened so that it wouldn't happen to another mother and to another child. If that happened, I'm not aware of it.
I've talked to you about this notion of apology, and maybe on the other side of the spectrum is this notion of accountability. What changes would you want to see in the litigation process? And could they achieve both, or are these mutually exclusive?
It's a great question. I'm not sure I'm the best person to answer it. I look out to this room and know that there's a lot of legal expertise in this room. We've talked about this, Richard. I will admit that the conversation of no fault interests me, and I'm aware that it is something that would make you uncomfortable. I will also note that you have a conflict of interest as an ethicist. But I'm someone who lived through the process. My son received a huge award. I've been led to believe it's one of the larger awards, and I'm not sure it was worth it. I'm just not sure if it was worth it. And so a process that offered a timely resolution, that allowed our family to have access to information, that allowed me to sustain a relationship with medicine, that placed my son's well-being at the center, and my well-being as a caregiver at the center of concern. That's, I think, ultimately what I would have liked to have seen, an accountability from medicine. So they stepped up and they honored, or they acknowledged what happened. They shared where the error might have happened. They talked about what would happen next so that it didn't happen again. I can accept, I'm going to be very clear here, I can accept the fact that a physician made a mistake. Even a huge mistake that ultimately was so serious, because doctors are human. People make mistakes, all of us. What I can't accept is a system that proceeded to torture my family for 13 years because someone made a mistake. A process to be accountable for that mistake, I think, is what I'm interested in. And I'm not sure if there was accountability. I'm not aware of it. I just know we got a lot of money.
What to your mind, does accountability look like?
Well, I think justice. I think honest conversations about what happened, clear discussions about the event, the error, the learning, what is going to be put in place to prevent that, emphasis on patient safety.
Okay. I'm going to deny any conflict when it comes to the issue of no fault.
Okay.
So, but when we talk about, we had, I think, a very important conversation this morning with Jan Marin and Brenda Agnew talking about what's available to families who do not have a right of compensation through the courts. And I think we did learn that it's woefully inadequate. No fault is something that brings the lowest common denominator to everybody.
I'm aware that you have concerns about undercompensation. I would look out to you and say, this is a room full of brilliant legal expertise, so take what's out there and make it better. I divert funds that are currently being used in lengthy litigation to support families. Make it accessible to more than 1%. And I'm what, 1% of 1%? So we had extraordinary resources for 7 years of my son's life.
So we do have potentially some changes coming to our system to make cases go through the courts more quickly. Whether it's going to work or not, I don't know. But
that'd be great.
We have rule changes coming in. But when it comes to cases like yours, we generally feel that you cannot resolve a case like yours until the child's at least 6 years old, 7 years old in most cases, because damages don't crystallize. That's part of the problem that we face. So
Well,
it's,
they were pretty clear pretty early on.
well, for you, they were.
Yeah.
Yeah.
My kid was on a feeding tube. He couldn't hold his head up. He choked on his own saliva. He had
Right.
seizures. It was pretty clear.
So what accounts for the 10 years to get to trial in
Ask-
your case?
Scorched earth policy by the CMPA, waiting to obtain expert opinions, delays in the legal system. I'm sure you're probably more able to answer that than I am.
How old was your son when you retained counsel?
Before the first year of life. My son was a lawyer, and we were worried, he was worried that because he knew the law, he would be held to a different standard.
husband?
Yeah,
Yeah.
that we would be expected to file within 12 months. So we did. It was filed before his first birthday.
Yeah. And so the 9 years to get to trial was collecting evidence, and what else was happening during that time?
I honestly don't remember, because I was providing 24-hour care.
Right.
I've been led to believe that this is how these things unfold, and so I didn't know to question.
I mentioned the issue of the damages, and I think when we initially spoke, you were a little surprised to hear from me that I thought that the Court of Appeal maybe had not treated you very well on that appeal. What were your thoughts about the damages award?
Yeah, that's a hard one. Thinking about sort of the economics of the lawsuit takes me in lots of different directions. We received a lot of money. I was the person who managed it, so I was very cautious with that money. I had been told that the judgment didn't include overnight care, so I was genuinely terrified to use it for overnight care because I don't know what rules I'm allowed to break or what rules apply to me. I've also lived 13 years now with the fear of financial ruin, so I'm frugal. I don't know, we received this money. I had no idea how to manage it. I had no idea what was considered an appropriate expense, what was considered an extraordinary expense. So there's that whole piece of the economic conversation. I will note that my lifetime of lost wages was valued at $100,000. So that's kind of offensive, but at the time I was only concerned about my son. So, sure, I can see where you're coming up with the fact that I was undercompensated, but it was better than what we had. For 13 years, we had no supports. And let's remember that I was an enormously privileged mother. I am married to a lawyer who is a partner in a big law firm. We could afford for me to walk away from my job. We could afford to pay, we had benefits. We could afford the cost of our drugs, or my son's drugs, and any drugs we might need. I knew people who were making decisions about whether to pay for seizure drugs or heart drugs. We could afford to pay a mortgage. Now, I was terrified that if we lost the lawsuit, we would be required to pay significant legal fees. I was also terrified the CMPA would come after us for their legal fees. So when I say I lived in fear of financial ruin for 13 years, I woke up, I would lose sleep. I would run through scenarios of what we could do, how I could find money. Would I have to sell my house? Would I have to purge our RRSPs? Had I compromised our children's financial security because we filed this lawsuit? Would I be able to pay for their university degrees? Those were things that were going through my mind until this resolved.
Most cases don't go to trial. We settle most cases. We have mediations, we have pretrials. Was there any attempt to resolve your case before you got to trial?
I asked repeatedly for alternative dispute resolution and was told it was not possible.
So they maintained a denial right through?
Yeah. I asked repeatedly. I was open to settlement. I made it very, very clear that I wanted this addressed as constructively and as quickly as possible, and that I was open to any conversation. I was told repeatedly no. Yeah, that was a disappointment.
You also spoke to me, I know this is revisiting more trauma, but you talked to me about your trial experience.
Oh, yeah. That was fun.
Why don't you tell us a little more about what it's like to be under the gun? I'm someone I like to think that is a bit of a Pollyanna. I try to see the good in people.
I have a hard time seeing the good in the CMPA. I was on the stand for a week, under cross for most of it. The entire lawsuit, like even discovery, like it was all traumatizing. I felt often bullied. I felt gaslighted at times. I felt that I was portrayed in all sorts of less than flattering terms, despite the fact that I really felt that I was a concerned mother who was seeking clarity about my son's birth and doing whatever I could to ensure that he had the best medical care. You need to remember, my son was very medically complex, that he would have the best medical care for his life. So I went up to the stand and I took a deep breath, and I basically let a woman attack me. I got off the stand, and our lawyers, when they were able to speak with me, admitted they were surprised by her behavior, because normally a mother is treated more gently than I was treated. I do note that the judge in his judgment noted the aggressive cross-examination, and that I was credible during such aggressive cross-examination, and noted the doctor was less credible, and I had some comfort there. But to pretend it wasn't traumatic, I'm a pretty stoic person. I hold myself together pretty well. And to say I was traumatized does not begin to describe my experience, to the point that I don't think a lot about this. I have self-protective measures in place. And to walk into this room and to speak to lawyers about my experience is something that took a lot of work on my part. But I do feel strongly this is a conversation that we need to have. I'm aware that I'm an outlier, that what happened to me is unusual. But I do feel that what happened to me is something you need to pay attention to.
So we did have this discussion earlier today about the fact that most cases settle. Our experience has been with, usually a giant sigh of relief on the client's part when a case does settle, but also, again, our experience, I don't know if it's universal, a degree of satisfaction often. So there are those other people. That's the case with most cases that settle. I'm not saying that everybody's happy with the result, but it's certainly better than going to trial. But do you, if we're in a case like yours where the other side is unwilling to settle, you have two choices. You can walk from your case, or you can try the case, and we always counsel our clients to try the case if we can't get resolution.
If I had walked from the case, I would have been responsible for the costs that I had incurred to date. So there is a sense that you can't walk from a case once you're sort of 7 or 8 years in. So there was that fear. By now we've incurred significant expert costs. Our legal fees were into the thousands, well into the thousands. So I think by that point you're so far down the path that I don't really feel we had an out. And we believe that we owe this to our child. And to be fair, our lawyers were encouraging. They were hopeful. They felt that there was clear evidence of a medical mistake and that they trusted the courts to see that. So I hope was really what sustained me through all of this. Was I satisfied? Was I relieved when it was over? Absolutely. Was I satisfied? Probably not.
So what advice would you have for other parents contemplating this? Stay away, don't do it?
Yeah, I often joke that I'm probably the best advertisement for the CMPA. I would encourage them to be very clear about the reason they're doing it. I would encourage them to ensure that it is a catastrophic injury before they pursue, and that if it's something relatively trivial, or not that it's trivial, because error is not trivial to someone who's experienced it. But if it's not a catastrophic injury, be very careful about moving forward, is usually what I tell them.
Well, in Canada, there are probably 300,000 adverse outcomes in hospitals a year. There's only 1,000 lawsuits.
Exactly.
And so most people don't pursue
Yeah, exactly.
lawsuits.
And I can understand why.
Yeah. Well, and we counsel. They're expensive lawsuits and they're risky. That's why we're here talking about risky business. But I guess you're in a bind as a parent when you get to that stage where your litigation is advanced, where there's no interest in resolution. you've got opinions that suggest your case has merit, you're really left with one choice but to try the
Yeah,
case.
at that point where there was no out, I felt. And you need to remember, my primary concern as a mother is my son. The only reason I was doing this was for my son. You know, I don't voluntarily enjoy being abused. I was protecting my child, so that was enough to keep me going.
Anybody have any questions for Laura, Jan? Let's get a mic.
Hi, Laura. I'm one of the plaintiffs' counsel at Gluckstein doing medical negligence work, and I'm curious, you looking back in your experience, taking away specifically what happened at trial with defense counsel or approaches that were described to you as, being CMPA approaches, how would you suggest that plaintiffs' lawyers can minimize some of the trauma of the system? This room has more plaintiffs' counsel in the room. What are the things from your perspective as a client? And I've certainly heard from Brenda and some of her thoughts, but I'm curious what you would tell this room, which has more plaintiff counsel here.
Well, I was thrilled to hear that Gluckstein Law seems to have strategies in place. So I'm aware that Brenda has developed an incredible resource. And I also get the sense that lawyers are sort of, and staff are involved in the process and provide as much support as they're able to. So I think that's huge. I think, providing as many resources as possible, information, knowing the system is fractured, the medical system now, I'm speaking of, is fractured, and that many parents who are providing the level of care I provided are just badly overwhelmed. We don't have the time to go looking for resources. So sort of a collection of that information is incredibly helpful. Emotional psychosocial support, I'm not sure if that's practical, but finding ways for mothers and parents to access that, primarily mothers statistically, to access that. The other thing I want to note is that after we received the award, we literally were handed millions of dollars and then people went away. And I was left as the fund manager of a multi-million-dollar chunk of money with zero training, with zero advice, with zero support. I had no idea what I was doing. There was no oversight. There was nothing. We were never audited in the entire length of the 7 years that I managed that money. I received no support. I know McKellar Structured Settlements was a little freaked out with me when around the age of 20, they realized that we hadn't filed for guardianship, but no one had stepped in and sort of said, gee, these are things you need to do. I had no idea what I was doing. So that kind of information for people who do receive money would be great. The only feedback I received was, here's all this money, be ethical with it. Fortunately, I'm an ethical person.
Right, so Jen and Brenda are very involved in providing that very service.
That's great.
Brenda, and Brenda, maybe just, you want to speak to that a little bit about the post-settlement, what we do post-settlement?
Laura, we were the same way. So we were, handed this award. Thankfully, very, very grateful for that. And then, what do we do then? And when we had to take a look at things like passing of the accounts, and we had to take a look at things like accountability for funds. And I would often have other families come to me to say, you've been through this process, what's your experience in that? So we sat down and said, there's a huge gap here. Yeah. These families don't know what to do. It's really not sort of the role. I mean, the plaintiff lawyers, they do an extraordinary job. They get the settlements, here you are, it's wonderful, but then what happens? And families fall into a void. Yep. And we know that there's consequences and repercussions if those funds are not accounted for properly and they're not utilized in an ethical way. So we actually put together a post-settlement guide. We took a look at, what are some of the gaps here? What is the information that we think we need to be sharing with those families upon settlements, and also people who work with those families to say, here's some guidance you can provide, because people had no idea. And I actually said, I remember calling Janet crying when I had to pass, it was the 2-year passing of the accounts. And I remember saying, this is harder than the entire process that I went through from,
Yeah.
there you go, I was re-traumatized.
Oh, yeah.
Because it's just, it was such a difficult process to go through. And I just thought at times, this is not worth this.
Yeah, and the uncertainty about even what was considered an appropriate use of the fund. And you need to remember, now I have extraordinary resources. I have more money than I have ever imagined we would have. And I'm not sure what I'm allowed to spend it on. Beyond medication and diapers and equipment, am I allowed to take my son to Disney with it? Am I allowed to make our cottage wheelchair accessible when we bought a cottage? What am I allowed to do? What's considered frivolous and what's considered appropriate? And I'm a frugal, reasonable, careful person, and I didn't know what to do.
Yeah, and those were some of the questions that we had as well, and I continue to get. I sat with a parent the other day that had a case at another firm, and they're in this exact situation. And can I take my son to the movies? Am I allowed to buy an adapted gaming system for him? Are we okay to go ahead and get a wiki trailer to take him on bike rides?
Yeah.
And I try to give off the record advice where I can, but it's important information for families because they do have this money. Not all of it is going to be dedicated necessarily to some of those buckets. So how can they make the most of their quality of life for their child and their family, right? And those are difficult, they're difficult decisions to come to.
And I know I struggled with again, the ethics of it, because my son dying with a whole pile of money in the bank that we could have used to improve his life is also unethical. So I really struggled with what is the fine balance between using this money wisely, using it well, and ensuring he has the best quality of life, knowing we didn't obviously know he would die at 21, but we had been led to believe that his life would probably be shorter than the average.
Right, well, life expectancy is always a difficult issue. We have a question back here.
Thank you so much for being here today, and I just want to say how brave you are to stand in front of all these lawyers. I'm not a lawyer. I'm a physician.
Great.
And
We could talk.
I just have to say how I really appreciate your perspective, and thank you for being here. I have a question. So, as you mentioned, medical errors occur. They're not all due to negligence. Actually, most of them are not due to negligence.
I would argue probably the majority are just mistakes. Yeah.
Right, and I've made several of those in the past, and will continue to make many. The CMPA is very clear with regards to how to disclose medical errors, not to apologize, not to, be careful when you interact with the patient, be careful with what you say. Anyway, there's a lot out there that we can and cannot do. Just human to human here, how would you have liked that disclosure to have been? What would have been ideal for you so you could have had closure? I don't even know if that's a thing, when you have a very sick child. Would you have been able to have closure had this disclosure been different?
It's a great question. I think initially, we need to remember during the shock of when something happens, you're overwhelmed, you're angry, you're frightened. So I need to acknowledge that during that time, I might have not been as constructive as I might have been 6 months later. But the absence of information is a problem. What would I have liked to have done, human to human? I would have liked the doctor to walk into the room and say, this happened. And we're not quite sure why we missed Matthew's size. Matthew was almost 11 pounds. There's a reason I could not deliver that child. We missed that. And this is why this has happened, and this is what we're going to do to make sure it never happens again, or that's not realistic. These are the things we're going to put into place so that hopefully we can minimize the risk of this happening again. And here are the ways we're going to support you, because now you have this very difficult journey. There's a reason I put that article in the Canadian Medical Association Journal and not elsewhere. I wanted to speak to physicians, in part because I feel that the scorched earth policy of the CMPA is not compatible with your worldview, if I'm speaking directly to you. It is not compatible with your ethics, with your call to your profession. And I would encourage the profession to stand up and have a meaningful conversation with the CMPA about protecting patients, because nothing about my experience with the CMPA protected me or my son. And I feel a little uncomfortable saying that, but it's true. And so I would ask your profession to change. And that's kind of what I was saying in the article. You guys need to stand up and take some leadership here.
I feel like we've ambushed Risa Kirschblum here a little bit, but I'm going to stand up for the I'm going to stand up for the CMPA a little bit. It's against my nature, but let me just say that on the other side of this coin is the fact that doctors are entitled to a defense if they think they have a defense there, and the CMPA does a good job in providing that defense. They always have very highly qualified lawyers who are providing the defense. So the doctors are, I think the vigor, I'm going to put it maybe in your case, maybe a little overzealous defense, especially at trial, not appropriate because the trial judge commented on. I would not call that typical.
Yeah, so we need to understand that I'm an N of one here.
Yeah.
And I may have had an overly traumatic experience, but my experience was deeply traumatic.
Yeah.
And at some level, I look to medicine, and I hold you responsible for that.
Yeah, so there are systemic problems throughout, I think, but I don't think I think there's a counterbalancing argument to some of this, and you have been through an enormously traumatic experience with a very aggressive counsel through cross-examination that even the trial judge had to comment on, which is maybe a bit of an unusual feature. We had another question over here.
Thank you for coming here today, Laura. What has the CMPA put forward about your case particularly to help other hospitals or any medical professional learn from this experience? Has there been anything at all?
If there is by the CMPA, I'm not aware of it.
Would it not be from them? Isn't there a CMPA person here?
No, there's a lawyer who acts for doctors, but there's nobody from the CMPA here.
No, I'm not aware. Interestingly enough, I became aware a few years ago that my son's birth was a case study in a midwifery program at McMaster. And I actually reached out to the dean. And I said, I'd really love to know how you discuss what happened. And I never heard back.
Call them again. I'll help you with that if you want. My name is Green Shine. You guys can look me up.
Anybody else? Any other questions? Pinta?
Not a question, but more of an observation, and I am a former CMPA lawyer.
I'm sorry.
It's okay. It's okay.
I'm just trying to be honest here.
And I'm coming at it from the perspective of someone who used to represent physicians. And what I hear from you is that something akin to more of a restorative justice type
Yes,
of stream.
Exactly.
And I think, from my experience at least, it is, in a lot of cases, deeply traumatizing and concerning for physicians as well to go through this process, right?
I agree.
So having that opportunity to have those sorts of discussions is really interesting. It's a really interesting concept. Because we're seeing it's kind of available in the criminal context, but not in all cases. But it's something certainly that we should think about as we move towards a more trauma-informed approach in dealing with these cases.
Yeah, but what would that mean for our tort system and the values of our tort system is what I wonder.
I will
Well,
just
we can
point-
talk about it, Richard.
Yeah.
Yeah, I agree. Like it's not my job to take care of the physician who injured my son, but I'm aware that probably this process was traumatizing for him as well. And, my son's partner is a physician, and we talk about the enormous pressure to not talk about mistakes. The other thing is, this is probably the only or the closest experience I've had to a victim impact statement. At no point was I allowed to speak to the medical legal community until very recently, when I published an article and you asked me to speak. So no one seemed particularly interested in my experience. And in fact, I will say that on the odd time I did bring it up, my experience with medicine is that they forcibly suppressed the conversation. They could not bear a conversation about the mistake of a colleague or the fallibility of the profession.
I wanted to add to sort of what Pinta said as well, and the next presentation actually is going to be talking about collaboration between plaintiffs' counsel and not just CMPA counsel, but also hospital counsel and all of those things. And I've had the benefit of working very closely with Brenda, who's a former client and someone who's been through the system. So I think that very much informs my personal approach. But I think, and I don't say this to you, Laura, because I think you're doing something so vulnerable in presenting your own traumas from the system, and it's why I asked the question about what I can do as an individual lawyer, those in my position. But I do think that plaintiffs' lawyers have such a responsibility in so many ways to lessen the trauma on our clients by properly informing our clients about what the process is going to look like, explaining at certain stages things that are going to be more difficult and why they might be that way. There are so many things we can do as individuals to reduce the trauma on our clients, including, the resources guides that we've put together that make this so traumatizing. And my experience working with so many, and Risa being one of them, but many, many others, is there are many counsel on the other side who do want to get these things resolved and do see those cases, and it's incumbent upon us, on plaintiffs' lawyers, to do things to push these cases forward, to prove our cases quickly, to know what we're doing, to specialize in this area of law is critical, because if you do not, and everyone's going to hear a lot in a minute from our talk about what happens when you don't have lawyers who are specialists in this area of practice. So from a plaintiff's lawyer, my perspective is not actually that I'm seeing the scorched earth approach in all my cases. I'm not. There are some more aggressive individual counsel, and I do think that makes a difference in different experiences. And I'm a bleeding heart for my clients. Like, I have cried with them. I really genuinely feel their pain. And what you're describing, Laura, is a nightmare. It's truly terrible, and not what I believe would be the experience for most. I do think it's on the more difficult side.
And I acknowledge that.
Yeah.
I acknowledge that I am probably an outlier.
Yeah. And I'm really sorry that you had that experience.
Yeah, me too, thanks.
But I think it's a really important perspective to hear about the system. I mean, Laura's experience is something that we as lawyers need to understand, right? Sometimes we're a little clinical in our approach to these cases, but all lawyers should hear this story and the impact that it has on people who have been traumatized. The adverse outcome is trauma to start with. Litigation is trauma. A trial is unbearable trauma, and the appeal and then it takes 13 years. You can understand how important it is to hear your perspective, and that's why I was so impressed by your article. And Laura, thank you so much for coming to talk to us about it.